Hello, everyone. I want to welcome you all to this really what I expect to be an amazing event. It's an enormous pleasure and an honor to be able to do so. This event is sponsored by the Georgetown Gender Justice Initiative, which seeks to promote and catalyze interdisciplinary scholarship, engagement, and activism on intersectional issues of gender, racial, and economic justice. I want to especially thank my wonderful colleague, Deborah Epstein, and the amazing executive director of the Georgetown Gender Justice Initiative, Melissa Huffaf, for their work in conceptualizing and really making this event possible. Bringing these brilliant women together has really been an act of love, anger, and passion for all of us. And Melissa is teaching right now. She'll be joining us shortly. And we're really excited to have you all. Thank you so much.
I'm Deborah Epstein, and I wanted to just take a few minutes to share with you all how this conference came into being, and then a bit about the logistics of how this day is going to unfold. So this summer, on June 24th, when the Dobbs decision came down, it was an unbelievable gut punch. We had all been expecting it, of course, because of the previously leaked draft, but actually reading the decision and absorbing the bottom line outcome that Roe v. Wade had been overturned, the contempt and scorn that permeate the opinion's language, and the outrageous illogic of its originalist analysis that seeks to return women to the status they held in the 19th, or at best, well, the 19th or maybe even the 18th centuries, was for me, as well as I'm sure for many of you, almost unbearable. And for several days, again, I'm guessing like many of you, I found myself in a state of total, enervating existential despair. But about a week into this new Dobbs universe, rage, really white hot rage, overtook despair. And my colleague Naomi and I, along with our G+JI executive director, Melissa Huffaf, rolled up our sleeves and began to plan this symposium in the hope that it might serve as something of a call to action. The Dobbs decision, as I'm sure many of you know, was the result of a 50-year systematic conservative movement to build judicial and political power. And our hope is that by bringing together the brilliant, insightful, creative thinkers that you're going to hear from throughout the day, all of whom have deep expertise in numerous areas related to reproductive health, reproductive justice, and equality, that we can contribute in some small way to the long-term counter movement to fight back that is now going to absolutely be necessary. We're really hoping to spark discussion, strengthen solidarity, catalyze activism around this oppressive decision that already has and clearly will continue to assault women's humanity and dignity and freedom and quality of life. So those are pretty high expectations for a day, I know, but I am really confident that our wonderful panelists are going to help us all think more deeply and systematically about the role that each of us can play. So here's how the day is going to work. We'll have 3 separate panel discussions. The first one that will follow this intro is entitled The Path to Dobbs, History, Ideology, and Race. The second is The Meaning and Effect of Dobbs, Originalism, Criminalization, and Health Justice. And the third will be The Future of Dobbs, Opportunities, Activism, and Creative Rage. And then we'll close out with a pair of short closing keynotes. You may have noticed that each panel has a separate Zoom link. We'll remind you of the link for the subsequent panel by dropping it into the chat at the end of each preceding panel. And to ensure maximum time to hear the wide range of speakers we've pulled together and to ensure meaningful time for audience participation, we've asked each speaker to limit their remarks to about 8 minutes. And we are going to limit ourselves to really skeletal speaker intros here. So we really encourage all of you who are participating to review the more detailed bios of these extremely impressive speakers. You can access them through a link we're going to post in the chat during each panel. Finally, during the panels, we really encourage you to share questions that occur to you as they occur to you by dropping them into by using the Q&A function. And the moderators for each panel will collect these and get to as many as we possibly can during the session. Thank you, everyone, for joining us. So we're going to get underway, and unfortunately, I have to start by reporting that our keynote speaker, Congresswoman Cori Bush, has had an unavoidable conflict this morning that's pulled her away at the last minute. We're so sorry that she can't be here with us, but we feel that the story that she has and the way that she tells it is so compelling and important to hear that we're still going to share a few words about her and then show you a very short video clip of her speaking about the Dobbs decision, particularly in relation to her own life. As many of you, I'm sure, know, Representative Bush is a registered nurse. She's an ordained pastor. She's a member of that U.S. House of Representatives. She is the first Black woman to represent the state of Missouri and the first Black Lives Matter activist elected to Congress. She has courageously shared her own personal story as part of a relentless effort to pursue racial, gender, social, healthcare, and environmental justice. And she has been a passionate and articulate advocate in demanding that Congress enact protective abortion rights legislation. I see her as a role model for all of us who care about equality and an end to human suffering. And with that, I'm going to ask that we play the video clip of Congresswoman Cori Bush, and then we will turn to Naomi and our first panel of the day. Thanks, everyone.
Many of you know my story. When I was 17, I was raped, I became pregnant, and I chose to have an abortion weeks later when I turned 18. That experience sits in the heart of my understanding of what abortions fundamentally are. They are indispensable, they are essential, they are non-negotiable health care. Since the day of the Supreme Court draft opinion, since it became public, I have been filled with even more righteous indignation for our entire country and the millions of people who will be impacted by this draconian decision. A righteous indignation for every person who knows how deeply personal and consequential private medical conversations and decisions are, and how important it is to protect our rights of privacy and bodily autonomy. If we fail to overturn the filibuster, if we fail to protect the right to safe and legal abortion in this country, if we fail to do our jobs, then it is Black and brown, indigenous people, LGBTQIA+ communities, immigrants, people with disabilities, people with low incomes who will die, period. Even with Roe in place, it is Black women and people who bear the brunt of unequal access to abortion care. The U.S. leads the developed world in Black maternal and infant deaths, and this is in no way a coincidence. It is Black women who are more likely to lack health insurance, quality sex education, and access to quality preventative health care measures because of the pervasive social inequities that too many leaders in our government refuse to acknowledge and rectify.
The ability.
Kyle, can you spotlight Naomi? And Naomi, you're on mute.
That was really wonderful. Even in video, I want to channel Representative Bush's righteous indignation for the rest of today, and thank Deborah for that beautiful introduction to the event. I'm going to remind everyone again that you can use the question and answer function of the webinar to ask questions. You can also access Zoom captioning. And I also want to thank our ASL interpreters for joining us today. They are going to take turns with every speaker. They're Dory Griffiths and Leo White, and we really appreciate your signing for us today. Let me introduce our first panel, and it is an enormous honor to do so. I'm going to give very brief introductions, and then I will post the link to the bios in the chat. First, we have Michele Goodwin, Professor of Law at the University of California, Irvine School of Law. Krystal Leaphart, Senior Policy Analyst for the National Birth Equality Collective. Tabacco, director of the ACLU Women's Rights Project. Rafia, Zakaria, author, attorney, activist with the African American Policy Forum and the Dawn. And Mary Ziegler, professor of law and a historian at the University of California, Davis School of Law. Kathryn Kolbert, a reproductive rights litigator and journalist, is not with us live. She has sent a pre-taped video, and we're going to start first with that video. Kyle, could I ask you to play Kathryn Kolbert's video?
Hello, thanks so much for having me at your conference. I'm so sorry that I can't be there in person, but I thought I would try today to outline how we got to the precarious state we are in, how the Supreme Court arrived at its decision in Dobbs, and most importantly, what we can do now to win back the reproductive freedoms that we have lost. As many of you know, I argued Planned Parenthood versus Casey in 1992, and at that time we thought that there were 5 votes on the Supreme Court to overrule Roe. Justice Thomas had recently been confirmed to the Supreme Court after the contentious nomination proceedings with Anita Hill accusing him of sexual harassment, and the nation was primed to now see the erosion or complete elimination of Roe. That didn't happen in Casey. We were very surprised that it didn't happen, and the only explanation is that Justice Kennedy switched his vote at the last minute, joining Justices O'Connor and Souter in the joint opinion in Casey, reaffirming the hallmark of Roe, but opening the door up to allowing many more restrictions at the state level that would erode the ability of women to obtain abortions. And how that happened, of course, is up to much conjecture. Chief Justice Rehnquist had already written an opinion overruling Roe. We found that opinion in Justice Blackmun's papers. It is not like the Dobbs opinion, but it essentially gave the states the ability to ban or restrict abortion in any way that they saw fit. But Justice Kennedy had a differing view, and I think that's important because he was looking for a giant compromise on this issue. It didn't work, and it didn't work for a couple of different reasons. Most importantly, it didn't work because of the politics surrounding abortion. And I think that is the biggest explanation about how we got to where we are. The court, from as early as 1974, had begun whittling away at the rights that Roe guaranteed. First, it was young women, then it was poor women, young women being required to obtain parental consent, poor women losing the ability to use their federal health insurance, Medicaid, to obtain abortions, and then eventually a whole host of restrictions that made it impossible for the most vulnerable in society to obtain procedures. That included Black women, that included all women of color, it included poor women, young women, disabled women, rural women, a host of people. And more states began to impose such onerous restrictions that the number of abortion providers in many states was whittled away to 2 or 3, in some cases even 1 provider left to cover an entire state. But the most important thing, I think, of how we got to where we are is that the anti-abortion movement aligned itself with the Republican Party. And they waged not just a legal strategy, but a political strategy to overcome the rights that we had taken for granted and that we had tried to secure through the courts. They were very, very smart, and they aligned with the Republican Party, and beginning in about 2010, the Republican Party began to take control of state legislatures, state gubernatorial seats, gerrymandered districts so that they could maintain that control. And sooner rather than later, they began to enact restriction after restriction after restriction that became law in those states. They also focused on state Supreme Courts that made sure that those onerous laws were permitted under their state law as well as under federal law. And then most importantly, politically, in 2016, with the election of Donald Trump, they maintained the power to appoint justices to the Supreme Court. Now, I learned everything I know about winning in the Supreme Court on Sesame Street. Why? Because you gotta learn to count. And the only number that matters is 5. If you have 5 votes on the court, whatever the rationale the court adopts, however absurd that legal reasoning is, if there are 5 votes to overrule Roe, if there are 5 votes to make changes, that is all that is necessary. And that's what happened here. An ultra-conservative majority of 5 justices eliminated rights that all of us have held dear for almost 50 years. And they did that not just by saying Roe is overruled, but by saying a couple of other really important things. They said more than anything that and provided a roadmap for eliminating all unenumerated rights. And that is incredibly scary, because not just the right to choose abortion is at stake, but the right to marry a person of your choice, the right to be sexual, the right to carry a pregnancy to term and make decisions about that pregnancy, the rights to use contraception. All of those rights, which are unenumerated based on the Liberty Clause of the 14th Amendment, are at stake. And therefore, it's really, really important that all of us begin to think politically about how to reverse these gains. For those of you, and this is the last thing I want to say, for those of you who had thought you would become litigators and fight for reproductive freedom or fight for other progressive causes, think about becoming a political operator, because politics is what is going to define our liberties going forward, at least until we make some changes on the Supreme Court. And lastly, it's really, really important that all of you think about this as a lifetime endeavor. It's not just the next election. It's not just the next 2 elections. We need to be vigilant politically and legally for all of our lifetimes in order to restore the reproductive freedoms that we have lost today. Thank you so much.
Thank you to Kathryn Kolbert in absentia. I'm going to go through our panelists now in alphabetical order. And just as a reminder to them, at the 8-minute mark, I'm going to jump in and just remind you to wrap up in 30 seconds to a minute from then. Michele Goodwin, can I turn to you?
You may, and thank you very much, and thank you to Deborah as well for bringing us all together. So my remarks will be framed around what I've been calling the new Jane Crow. To be clear, the Jane Crow theory is something that calls to mind from Pauli Murray, who was a predecessor to Ruth Bader Ginsburg at the ACLU, a predecessor to Thurgood Marshall, and who really laid the groundwork for what we now live in terms of racial justice and sex equality. Perhaps at another time I could speak more about Pauli Murray, but for all of those students and non-students who've not heard of Pauli Murray, I urge you to look at the important scholarship that was developed through Pauli Murray that served as the backdrop for what we understand today in terms of many equality theories. So when we think about how we got to this point of the new Jane Crow, much of it like the old Jane Crow, the old Jim Crow, very restrictive, restrictions that we can see delineated along the lines of race, but that also intersect sex. And in this Jane Crow, it's not something that is limited to women of color. It is important to understand that women of color have served as the euphemistic canaries in the coal mine when we think about matters of inequality, particularly in involuntary reproductive servitude. And I will talk about that in my remarks. So Dobbs, if one reads it clearly, it is an opinion rooted in selective reasoning, if not opportunistic reasoning by the court, a kind of cherry picking throughout American history and also American jurisprudence. And in that cherry picking and selective reasoning, there's also a selective disregard that one notes from the very beginning, just in terms of how Justice Alito and the majority regards fellow jurists who previously supported abortion rights. It's a level of disdain that we do not see even in the wake of Dred Scott or Plessy v. Ferguson being overturned. In fact, it is really unparalleled in American jurisprudence to see that level of venom directed at fellow jurists, just something that we've not seen before. But let's dive in. So many people place the starting point of the overturn, in this case, Roe and Planned Parenthood v. Casey, as being centered just around Roe, the discourse. And I think that that overlooks a couple of things. One, it overlooks Skinner v. Oklahoma, 30 years before Roe v. Wade, where the Supreme Court used the language of human rights and civil rights to describe the importance of an individual's decision-making in reproductive matters not ceasing because the state has decided to interfere in that reproductive trajectory. The Supreme Court talks about a human right and civil right for individuals to determine their own reproductive futures. And it is a unanimous decision 30 years before Roe v. Wade. Now, it is a case that involves a man's reproductive freedom, and it is a case in which the state of Oklahoma selectively was singling out poor people, poor men, petty criminals, for coercive sterilization. And one could speak more about that, but I'm mindful of time. Most important is to note that Roe v. Wade and reproductive freedom was not something that started in 1973 with regard to women and abortion. It's also worth noting that at that very time within the US military, women were commanded to have abortions if they became pregnant in the US military. And notably, the case of Captain Kathy Strzok, was the case that Ruth Bader Ginsburg had hoped would go to the United States Supreme Court because she, a captain in the military, was being compelled to have an abortion against her will if she wanted to stay in the military. But we have to dig even further than that to understand that when we talk about reproductive freedom and also involuntary reproductive servitude, this starts at the very foundation of what becomes the United States with the coercive kidnapping, the forced kidnap, and sex and labor trafficking of Black women. The earliest American laws instantiated exactly the freedoms that Black women could not have and the freedoms that would be tolerated by those who captured and enslaved them. The earliest American laws dating back in colonies like Virginia, that children would inherit the status of their mothers, a departure from European law, which essentially meant that Black women's bodies were vulnerable to sexual assault and rape, and that their offspring would simply become the capital, the property of those who own them. That coinciding with laws that provided for the disciplining, even killing of enslaved people in order to keep that system functioning in the way that would maximize profits for those who would own Black women, Black girls, and more. Now, make no mistake that when we think about involuntary reproductive servitude and its history in this country, that the dismantling of American slavery through the 13th Amendment also included dismantling this involuntary reproductive servitude that Black women experienced, to the extent that the Supreme Court says that it was never imagined, thought about, countenanced anything about involuntary reproductive servitude, that there were rights that never existed in this lane. It was almost as if the Supreme Court never bothered to look at the 13th Amendment, the legislative history surrounding it. I'm talking about Senator Charles Sumner being beaten nearly to death in the halls of Congress 2 days after giving a speech about Black women's involuntary reproductive servitude. I'm talking about a litany of articles written by the papers of record at the time, the New York Times and others, that this was at the forefront of what abolitionists were arguing about and the lane in which they were choosing to argue about the dismantling of slavery, that it imposed upon Black women involuntary reproductive servitude. And this is no mistake. Written about by Black women and given by Black women in speeches such as Sojourner Truth and Ain't I a Woman, starting off her speech in saying, "And I bore 13 children, and saw nearly each one snatched from my arms, and nobody heard my cry but God." Ain't I a Woman, all the way to members of Congress, the abolitionists in Congress, who brought us the Reconstruction Amendments, the 13th, 14th, and 15th Amendments. But let me say this, and I know that I'm coming close to my time of closing, but I want to make a few comments before I step off. And that is when we see the turn to abolishing slavery, the criminalization of it, it is in direct response to the momentum being gained by the abolitionist. Horatio Storer, Joseph DeLee began writing about the urgency of white women using their loins and going north, east, south, and west to combat what will be coming, which is the old-fashioned version of what it is that we're hearing today, replacement theory. That becomes central to the landscape and argumentation for criminalizing abortion and for pushing women out of providing reproductive health care for all other women. It's worth noting that in the 1800s, nearly 100% of reproductive health care was done by women, but those who bring us the anti-abortion movement, the criminalization movement just before slavery, turned this space into being one that by the early 1900s, women represent only 1% of those who are doing reproductive health care in our country. Now, let me close out with this. When we think about the legacy of what got us here, we can't just make this about an anti-abortion movement over a half century being successful. The reality is that there are also failures within the reproductive rights movement, the failure to recognize the criminal punishments that were being enacted and enforced upon the lives of Black and brown women in the 1980s and the 1990s, about Black women at the Medical University of South Carolina, dozens of them being dragged out of the hospital in shackles and chains, these women wanting to be pregnant, but who had been caught in a dragnet of explaining to their doctors their struggle with cocaine, crystallized cocaine, the very selective way in which Black women were singled out, 10 times more likely than their white counterparts to be reported on during pregnancy. That also is a part of this story, that part of the story that is about creating personhood through a criminalization movement that was also tied to an anti-abortion movement. Now, where do we go from here? Because I do believe in silver linings, and I do
Let me give you
believe
the
that
30-second mark.
Thank you. And I do believe that one exists here. And that is a third reconstruction is what this calls for. That is the centering of lives of Black and brown women, the centering of women and girls, of people who are LGBTQ and individuals with disabilities. Thank you so very much for having me, and I look forward to our Q&A.
Thank you so much, Michele, for that expansive and powerful reorientation of how we got here. Let me turn to Krystal Leaphart. Thank you, Krystal, for being with us.
Thank you so much for having me here. I'm going to attempt to share my screen. Hopefully you all can see the slides. Okay, perfect. So I'm just going to spend a little bit of time today talking about some of the more recent things that Black women and Black feminists have done to further the causes for abortion access, equitable abortion access, and just really reproductive justice overall. This is a little bit about NBEC, which is the organization that I work with. And essentially, we're not going to read all of this, but just giving a little bit of a primer in the sense of we approach this work from a reproductive justice lens. We focus solely on Black maternal health, infant mortality, and maternal mortality causes. But of course, you cannot focus on those issues without talking about access to, again, equitable abortion, and also making the connections between states that are attacking Black maternal health issues and also states that are attacking abortion access as well. A lot of the work that we do calls us to look back. We use this reference to Sankofa often within our organization, and essentially what this is an Ndingra stamp that is indigenous to African folks and African American people, and the diaspora use this to make sure that we are keeping front in mind, looking back at our past to inform our future and how we go about solving a lot of our issues. And the reality is Black women are not new to this work. Reproductive justice may have been coined in recent histories and herstories, but we've been doing this work prior to even being brought here, but particularly within the last 400 plus years. And I believe a lot of folks also can agree that a lot of the reasons why we have found ourselves in this moment is because we did not reference and leverage the work of Black feminism as much as we should have. And it's very much documented the kind of campaigns and things that have happened, but because that work is not held to the standard and excellence that it should be, we're finding ourselves kind of figuring out now what we can do with this work that has been here to help inform the ways that we go about doing things. So I wanted to lift at least three different campaigns and also talk about how that's informed work going forward for us. So the first thing that I wanted to lift was the African American Women for Reproductive Freedom Collective. That was a group of women that were well known in the civil rights community that came together to produce a brochure talking about the connections with abortion and Black women and making a lot of those ties to clarify the relationship between those things. We know that coercion, control, and all these things play a very clear role in the work around anti-abortion campaigns. And there's a clear connection in the ways that reproductive decisions have been essentially taken from Black women. We've never had full autonomy in that sense. And these women came together, to lift that and make that connection within that brochure. The second piece is the collective of Black feminists that came together to create the African American Women in Defense of Ourselves Collective. And that was the group of Black women that came together to place an ad in the Sunday New York Times in defense of Anita Hill during the confirmation hearings of Clarence Thomas. So now again, looking forward, I believe this was the year I was born. So 31 years later, I'm looking at that and really making that connection between what we're seeing coming out of the courts now, and had we heeded some of these warnings, or at least been somewhat ahead of these warnings, who knows where we may be now as we're thinking about the courts. And lastly, I believe the graphic is there. This is the Women of African Descent for Reproductive Justice. So this is the collective of 12 Black women that came together to coin the term reproductive justice. It is another additional way to call out the racism and the erasure of Black women within reproductive rights spaces, but also making those connections that this is not just about access to abortion for us, but this is also how we are able to raise children or not, how we're disproportionately affected by reproductive illnesses. And again, just recalling that same work that's been taking place at least 350 years prior to the times of these campaigns. So as we're looking forward, again, MBEC keeps all this work we keep this work in mind, we keep this very sacred, and we treasure the work that people have done before us. So we launched a campaign earlier this year in January, talking about the connections between abortion and the Black community. And we were able to secure a lot of organizations from legacy environments and elected officials to sign on to this campaign, just to, again, make that connection and highlight the importance of the work that Black women and Black feminists have done over the time we've really been here, to make that connection and really also do that work of remembering. Again, if we have so much to work with and so much to reference and hold in high regard. But if the larger reproductive rights and really just cross-sector communities are not holding that work sacred, it's falling on some lost ears, and we're missing very key opportunities to engage in this work. Lastly, I'll just talk about an amicus brief that we were a part of with 400 plus other organizations. And I'm happy to link the brief in the chat. But essentially, we filed this to just make that connection clear and have it on record that abortion restrictions are not protecting Black women's health. Again, those states and places that don't treasure abortion access and don't think it's important also don't think that family forward policies are important, paid leave, sick leave, access to care, and things like that. So there's a very clear connection between the issues that we advocate for and access to equitable abortion. With that, I'll just close and make sure that Folks are lifting the work of folks like Barbara Ramsey, Dr. Kimberly Crenshaw, and the creators and Four Mothers for Reproductive Justice, making sure that people understand the importance of cross-sector communication. If you are whatever field that you're in, there is room and space and opportunity for you to further the causes of reproductive justice, but also heeding to Black women, Black birthing people, and Black feminists to inform the work that you're doing. And of course, looking back as much as possible and remembering the work that's happened to better inform the work moving forward. With that, thank you all so much for having us here, and looking forward to hearing more about the work that other speakers are doing.
Perfect and amazing timing. And thank you so much for lifting up the crucial work of Black feminists. Let me turn now to Ria Tabacco Mar.
Hi there, and thanks for the intro. I never sure when we're going in alphabetical order if I'll be alphabetized under T and M, so it was an exciting drama there, waiting to hear if my name would be called. I am so delighted to be here with all of you, and I really appreciated the prompt and the invitation to consider the Dobbs opinion together, because I wanted to take this opportunity to talk with you and to also hear from others about something that's been bothering me since the day the case was argued, and I think has been bothering many, and that's the way that the opinion invokes both the Plessy decision and the Brown decision. I was delighted to hear Michele pick up on this as well. And, you know, listening to the audio of the argument and hearing the justices compare Roe to Plessy and what then seemed inevitable overturning of Roe to Brown instinctively struck me as wrong. I think it instinctively struck many folks as wrong. And since then, I've read so many interesting think pieces about what precisely was wrong with that comparison, and yet I still have the unsettling feeling that I haven't quite fully wrapped my mind around it. So I just wanted to name a few things that I've been grappling with, and I'm curious to hear from others in the Q&A how they're thinking about it. You know, the first was shortly after the opinion, we saw a terrific statement from Sherilyn Ifill, who was then president and director counsel of the NAACP Legal Defense Fund, essentially making the point that, you know, Roe was fundamentally about recognizing equality and dignity of all people, as was Brown. Plessy, of course, was the inverse of that. And so if you think about what the decision means in terms of people's dignity and autonomy, what appeared then to be the outcome of Dobbs is, of course, the antithesis of what Brown stood for. You know, then there's sort of just this idea that, well, you know, time marches forward with an expansion of rights, and that in fact, the Dobbs decision is more aptly characterized as a return to Plessy rather than the reverse. And this is something I've been thinking about a lot, but only began to make sense to me when I was rereading the work of Richard Delgado, talking about the practical realities of what the Brown decision meant. And after rereading Professor Delgado, I began to see that it's not only that the Plessy decision and the Dobbs decision bear sort of practical realities in terms of their impact on real people's lives, but the reasoning of the opinions themselves actually bear some striking similarities. And I just wanted to draw attention to three of them because rereading the Plessy decision after reading Dobbs, I think is quite striking. And every time I read the decision, I find some contemporary relevance to whatever is happening. So I invite everyone to reread the decision, but reading it through the lens of Dobbs was particularly disturbing. So the first comparison I wanted to draw is what I think can be best summarized as, I'm sorry you feel that way. And this, of course, is the most famous or infamous quote from the Plessy decision, where the court says, essentially, if folks think that separate but equal is discriminatory, that's your own damn fault. And as the court puts it, we consider the underlying fallacy of the plaintiff's argument, again, that argument, the notion that separate but equal is inherently discriminatory, to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction upon it. Again, here's the Supreme Court essentially saying, I'm sorry you feel that way. And we see that in the Dobbs opinion, where the court attempts to take down the notion that restrictions on abortion are a form of sex discrimination, this stubborn refusal to see discrimination where it exists, what Delgado calls the crabbed formalism of the Plessy opinion, we see here too, with the court saying, well, you know, some people think that restrictions on abortion are sex discrimination, you know, like little folks like the Solicitor General of the United States and, this long list of constitutional law scholars. Some people say this is discrimination, but if you think it's discrimination, it's just because you don't understand the distinguishing between pregnant people and non-pregnant people, just isn't about sex. Again, I'm sorry you feel that way. A stubborn refusal to see how discrimination operates, what discrimination means. And of course, anybody who looks beyond the words of either opinion understands what's happening, as Justice Harlan called out in his dissent in Plessy. And Harlan, I think, puts it best when he just says, everyone knows, everyone knows, he says, that what this is really about is white supremacy. And the same can be said in the context of Dobbs, right? Everyone knows that it's impossible to separate pregnancy, reproduction, parenting from patriarchy, from misogyny, from restrictions on our bodily autonomy. Everyone knows, right? And yet everyone knows this. And the court says, if you think you know that, well, I'm sorry you feel that way. The second aspect of the Plessy opinion I wanted to call out, I think, can be summed up as the, haven't we done enough for you people line of thinking. And this actually, I think, is best reflected not so much in Plessy, but in the sort of contemporaneous civil rights cases where the Supreme Court said, well, yeah, we emancipated you from slavery and we've simply done enough. That doesn't mean you're entitled to equal treatment in places of public service. And the court really expressly uses this notion of special rights in civil rights cases when it says, when a man has emerged from slavery and by the aid of beneficent legislation has shaken off the inseparable concomitants of that state, remember, we're talking just years after emancipation, there must be some stage in the progress of his elevation when he takes the rank of mere citizen and ceases to be the special favorite of the laws, special favorite, the recently emancipated slave, when his rights as a citizen or a man are to be protected in the ordinary modes by which other men's rights are protected. Again, haven't we done enough for you people? And I really heard this in the argument at Dobbs when Justice Barrett essentially suggested that abortion was no longer necessary for women's economic security and freedom. And we saw Justice Alito embrace it in the draft and final opinion, where he sort of lists what he calls modern developments that he says essentially wash away the financial and physical implications of being pregnant. So he says, well, now federal and state laws ban discrimination on the basis of pregnancy. P.S. no thanks to you, Supreme Court, which has repeatedly said that federal and state laws don't ban discrimination based on pregnancy, forcing Congress to legislatively overrule those decisions. But nonetheless, now those laws exist. Leave for pregnancy and childbirth are now guaranteed by law in many places, he says. Costs of medical care associated with pregnancy are covered by insurance or government assistance. So again, haven't we done enough for you people? The last parallel I wanted to highlight today is this notion of returning the question to the states. And, this is the piece that I think has gotten the most attention in sort of the public discourse and is also the most troubling if you think about what comes next. So the Plessy opinion spent a great deal of time emphasizing that this was really about Louisiana's choice to consign Homer Plessy to a separate colored-only railroad car. And it says, well, this isn't about a railroad that travels across the country. The train that Mr. Plessy was on, though of course they didn't call him Mr. Plessy, the train that Mr. Plessy was riding on had both of its terminuses, within the state of Louisiana. So really, folks, this is Louisiana's business, and what they want to do in their great state is up to them. If they want to say that Homer Plessy can't ride alongside white people, no harm, no foul. And the premise of the Dobbs opinion is essentially the same, that it is acceptable, in fact, preferable to leave individual dignity and autonomy up to the states, as though the choice to recognize one's full humanity and not recognize one's full humanity are entitled to equal dignity under the Constitution, that those choices are morally equivalent, they are constitutionally and legally equivalent, and we simply have nothing to say about which choice the state makes. That, I think, is troubling because when we look at Professor Delgado's work, writing in the context of the court's race discrimination jurisprudence and thinking about how the affirmative action context, the minority contracting context, all of those saw great retrenchment from the Brown decision. And Professor Delgado posits that where we're going in race discrimination law is actually not only back to Plessy, but in fact, all the way back to Dred Scott. And I think we've seen that timeline stunningly quickly accelerate in the context of abortion and reproductive freedom, where, just weeks after, immediately after the decision, we've seen dozens of states act to restrict abortion outright. We've now seen the introduction of a bill that would be a national ban on abortion, which, of course, national ban is a bit of a misnomer. It's really just a ban in those states that were exercising what Justice Alito just said was their constitutional choice to protect the right to abortion. So we've seen this incredibly rapid backward slide. And I'm not sure it's right to call it backward, because it's not so much that we're going backward, we're going forward. That's the very nature of the thing, is that every advancement is met by an equal and, in fact, oftentimes more intense retraction and entrenchment of the forces of white supremacy and patriarchy. And we are seeing that happen at disturbing speed right before our eyes. So I look forward to hearing from all of you on the panel and all of you in the audience. Thank you so much.
Thank you so much. And sorry for the not letting you know which last name we were using to alphabetize you, Ria. Powerful words. Let me turn next to Rafia, and thank you so much for being here. Right now I can't see or hear you live, Rafia.
You should be able to see me.
Now I can see you and hear you. Thank you.
Okay, great. Thank you, and sorry for that small hiccup there. The words that Ria's words really resonated with me, in that I am here in the States where this is taking place. I'm speaking to you today from Indiana, where where we all have already passed our abortion ban, and where a feticide law already exists and is, we have literally Secretary of Attorney General chomping at the bit to use that to to punish any woman who even perhaps shows up to an emergency room with a miscarriage. So that's the situation here. My own background as an attorney is in immigration law, and one of the most unforgettable instances of being involved with a client who needed an abortion is a case that I worked on, in which there was a young Sikh girl who had been trafficked across the Seattle, Washington border from Canada, smuggled in a truck, a semi, and brought to Indiana, where she was enslaved and was kind of used sexually by various distant family members, who had kind of, quote unquote, bought her from her family in India. So this woman came to the shelter that I worked at, and we soon found out that she was pregnant, and I had to take her to a hospital, where at the time, of course, abortion was legal, but there were all sorts of, all sorts of little things that they were trying to do, obviously, to deter her from that abortion. And the reason why I tell her, which she was eventually able to obtain, and the reason why I begin my comments with her story is simply because I feel that it is very important to expand as much as possible the pictures of victims that people see when they think of women who are being denied this right. At that time, She was, this is before the Trump administration, so the federal services that were available to her and as a victim of trafficking were not abridged in the way they would be today. So today, even if she was in a state that where abortion is not yet banned, the federal curbs on use of funds to provide termination of pregnancy would mean that, on the terms of healthcare, she would not be able to obtain an abortion with those funds. And it's questionable whether she would be able to retain all the other services she received federally. So this is an example of a brown immigrant woman who had just turned 18. She didn't quite know how old she was. Who would, is one of the people who's suffering from what has happened in Dobbs. And the second reason why I bring up her case is because of the picture of and the public discussion around Dobbs that has started to take place on, among other venues, the New York Times, which is the paper of record. And this has been a largely second-wave feminist-led discussion around sexual liberation and sexual pleasure and sex positivity. And the idea that, and this stems from some of the history of Roe, which, came at a time in which a very white-centered feminist movement was simultaneously agitating for sexual liberation and for the right to abortion. And the reason why I bring that up is because I'm also a Muslim woman. And because of being a Muslim woman in the past, I have felt very uncomfortable in the pro-choice sort of milieu, even though I've always been pro-choice and most Muslim women are pro-choice. One reason for being that is, of course, that and this was actually included in a amicus brief that was filed with the Dobbs decision, that in most Islamic scholars permit abortion. Many permit it up to 120 days, where 120 days doesn't even begin, at conception. It begins far later than that. Point being that there is, wide, and even beyond that 120 days, it's, supposed to be a woman's personal decision decided with her physician. So, here you have a group of women who are very, very sort of invested in, in being pro-choice and in retaining that right. But, the previous formulation of the pro-choice movement as sort of entangled with a sex positive movement for sexual liberation, with which, they have some, they have disagreement, perhaps not based on content in terms of sex positivity, but in terms of the performativity of sexual liberation. And I think that this is a point that hasn't been made that really needs to be made, is that for us to broaden as far as possible the pro-choice movement going forward, it is perhaps essential to disentangle it from, a movement for sex positivity and sexual liberation that must also continue without any doubt, and with, of which I am a part as well. So that point, I think, is, was really like one of the very important decisions that, points I think needs to be made. Also because some of the justices that were in Dobbs who were in favor, like Justice Sotomayor also said, isn't this a religious question? So the free expression part of, of Dobbs really needs to be as much at the forefront as, the equal rights portion of the argument. Finally, my point, because I work in the field of international development as well, and because what has happened now will have consequences in terms of the services to be provided by USAID abroad, and USAID in the past did provide, access to reproductive choice through programs run through funds reserved for healthcare. This, unlike many I don't want to put down all development programs, but there are many development programs whose takeaways are somewhat questionable compared or not as concrete as healthcare, where a service is provided and that is something very concrete that a woman is able to get safely. These services are crucial and form a very integral part of what the US has been doing around the world. But Trump era restrictions have already curtailed that, and the passage, the Dobbs decision threatens to almost eliminate that completely, such that it's not just health services, but also contraception that is no longer being provided. And I think that it's important to keep that in the discussion as well, because it illustrates the international repercussions of the Dobbs decision. So I don't know if
I was just about to give you the time.
Okay. Great. Thank you so much for letting me speak, Deborah.
Thank you so much for that and for those comments. I'm going to turn now to Mary Ziegler. Before I do that, I just want to remind everyone that they can pose questions for the panelists in the Q&A, and the panelists themselves can pose questions for each other or respond to comments that each other has made. Mary.
Sure. So I'm going to talk a little bit more about the history of this, since I'm a historian, and how I think we got where we are. And to start by saying that while this is certainly a story about attitudes toward women and other people who can get pregnant, and it's a story about attitudes toward women of color, it's also a story about the erosion of democracy. So that piece of the story, I think, begins really clearly in the aftermath of Planned Parenthood versus Casey. So as Kathryn pointed out, in the late 1970s and early 1980s, the anti-abortion movement was able to form a partnership with the Republican Party. And that had been the game plan, right? If you have a Republican president and Republican senators, you will get the right justices confirmed to the Supreme Court. Even before that, the plan had been, if you had a Republican president and Republican senators, you would have a constitutional amendment banning abortion. So just to be very clear, that's always been the goal. States' rights was just an argument of convenience that emerged later when the Supreme Court was what was up for grabs. But then you move to the moment that Kathryn litigated Planned Parenthood versus Casey. And of course, you have a court with 6 conservative justices that declines to overrule Roe v. Wade. And so within the anti-abortion movement, there's lots of evidence of this in the archival record. There's a lot of kind of searching about what went wrong, right? We have a Republican supermajority. We have presidents who've been vowing to undo Roe. And the answer overwhelmingly was a combination of the American people do not want an abortion ban, and the Supreme Court is attuned to popular opinion. So the movement began working on 2 fronts to change those things. The idea that they would convince the American people to oppose abortion, but that they would also convince the Supreme Court not to care about the American people, right? So a different kind of Supreme Court justice was needed. And if to get a different kind of Supreme Court justice would require a different relationship with the Republican Party. So historians, political scientists, and others, until quite recently, describe social conservatives as the sort of junior partner in the Republican coalition, right? A coalition between social conservatives, fiscal conservatives, and others. A famous expression among historians went that the religious right got from the Republican Party pretty speeches and nothing more, right? So, and the anti-abortion movement felt that way too. So the question was, how would the movement get more influence when, after all, we know something like between 18 and 13% of Americans only want something like an absolute ban on abortion? It seemed like abortion might be bad politics. And the answer, in part, for many in the anti-abortion movement was money, right? That the anti-abortion movement would have to buy more influence in the GOP, would have to help the GOP gain more influence by finding loopholes in existing campaign finance regulations, would have to join a fight to limit access to the vote, and a fight to deregulate campaign spending. So if you look closely at many of the major campaign finance cases in recent decades, anti-abortion groups were involved in them or were the parties in them. If you look at recent fights about access to the vote, or even the January 6th insurrection, anti-abortion lawyers are also heavily involved in that litigation as well. And the purpose of this, I think, was twofold, right? One, it was a way of showing the GOP that the anti-abortion movement was valuable, regardless of whether the American people wanted an abortion ban. And it was eventually became a way of kind of changing the balance of power in the GOP. In a world where we have Citizens United, right, which of course allowed unlimited independent expenditures from corporations, outside spending groups, and particularly right-wing movements like the gun rights movement, the anti-abortion movement, were able to gain more leverage, right? They were able to give a lifeline to extreme candidates who might have been kind of crushed by the party's soft money spending in the past. And that ultimately became the goal, right? I think over time, by 2010, when states for the first time across the South and Midwest were becoming solidly Republican, and not just solidly Republican, but politically uncompetitive, anti-abortion groups were realizing that policies in those states, right, where there was functionally no political competition, were the only ones that actually matched what the movement wanted, right? That would be to say bans with no exceptions for rape and incest, potentially bans with no exception for the life of the pregnant person. And so increasingly, the movement returned to its original premise, which was, this is a cause that is more important than democracy. This is a cause that matters more than what the American people think. From the standpoint of people in the movement, this is the sort of human rights cause of the century. That's how they would frame it. But another way of saying that essentially is that this is a cause that matters regardless of whether voters are interested in it. And increasingly then the move has been toward eroding democracy, eroding the aspects of the Republican Party that care about electability, and putting in place politicians who are beholden to social conservatives. And I think that's part of how we get where we are. The other part of how we get where we are is that the anti-abortion movement and other conservative groups develop this idea that we need Supreme Court justices who are indifferent to popular opinion. And unsurprisingly, given the focus we've had on people of color, the kind of seminal moment for this involves the accusations of, and I think trauma experienced by Anita Hill in the 1990s. So Clarence Thomas becomes to the anti-abortion movement the kind of dream Supreme Court justice. That is not because he's an originalist, although they like that. That's not because he had a track record of giving speeches about abortion and other issues where he more or less telegraphed his views, right? Comparing abortion to the Holocaust, for example. It's how he responds to Anita Hill, right? And people in the anti-abortion movement say, if he even relished the scandal and the controversy provoked by this woman of color accusing him of these awful things, he will be willing to relish the same controversy that will ensue if Roe v. Wade is overturned. He will be the justice who will not waver like Anthony Kennedy when the moment comes and the pressure is on. And so the movement concludes, we need more justices who don't care about popular opinion. We need the kind of truly counter-majoritarian court that Alexander Bickel had been worrying about since the 1950s. And so you see in 2005, right, George W. Bush nominating Harriet Miers, and there being huge pushback from social conservatives because she is not the next Clarence Thomas. And of course, who replaces Miers when she withdraws? Samuel Alito, the author of Dobbs. So I think part of the way we get here is that our democracy has been eroding. Part of the way we get here is that our court is increasingly detached in any way from kind of political pressure or the views of the American public. And that's dangerous, I think, and certainly not unprecedented in American history, but unprecedented in recent decades. And that means, of course, that while this is primarily an issue that concerns people of color, people who can get pregnant, women, it's an issue that concerns all of us, because the erosion, the damage done to our democracy by the fight to get rid of Roe will affect people regardless of whether they can ever get pregnant or give birth. So I don't know where I am on time, but I'll just stop there anyway.
Thank you so much. You okay. Have a spare minute and a half, but you're good. So let me do this, which is I would like to first, before there are questions in the question and answer portion, before I turn to them, I want to thank the panelists for their brilliant and insightful remarks, for what you've shared, both in terms of how we got here legally, politically, racially, and invite any of you to respond to each other. And the reason we kept the remarks short was because we wanted this to be a full and robust conversation, interactive, and I will bring in the comments from our audience. But let me open and if I could have Kyle's help in bringing the entire panel into the spotlight, I would like to open it up to our panelists first. Thank you. Does anyone want to respond to Ria's question, actually, about what we make of Dobbs as a decision, the disdain and depreciation that is built into the language and built into the way in which it references Plessy, Brown, and other decisions?
I'll take up that invitation, Naomi. Which is, again, in thinking about this as not being a new playbook, but an old playbook. If we think about the Supreme Court term as only concluding with Dobbs, but beginning with Texas's SB 8, a Texas law that brings us back to the Fugitive Slave Act, one that weaponizes civilians being able to spy upon, hunt upon, and get a reward in the denying of someone else's civil liberties, basic human rights, then we see this return to a playbook deep from the past. It's not that the individuals who are doing this are brilliant. Is that they can call upon what's been done in the past. And if you think about the cruel joke that's found in Dobbs, part of that cruel joke in telling the people of Mississippi, the women of Mississippi, the Black women of Mississippi, a state where if you're a Black woman, you're 118 times more likely to die by carrying a pregnancy to term than by having an abortion. That cruel joke is just go vote. Now we have to understand that he's saying this to people that a Mississippi that has never sought to secure Black people's rights for anything, save federal intervention, save the Supreme Court intervening, save the Congress intervening, save executive order intervening, a place that demanded that Black women have to guess how many bubbles on a bar of soap, how many jelly beans in a jar, or recite the state's constitution in order to be able to vote. And I think that so much of that is born within what Ria laid out in her commentary. It is the emperor has no clothes and we see you. I mean, that is the point of Justice Harlan saying, we see you and everyone sees you. Just own up to the way in which there is disregard and disdain for the lives and the safety of Black and Brown people and women generally.
I mean, the other thing I'd add too is that if you studied the anti-abortion movement, this is like a really long anti-abortion list of talking points, right? So the comparison to Plessy is not just something that Samuel Alito stumbled upon in his brilliance. That's been in, I mean, you can literally find law review articles from the 80s saying draft opinion of, something overruling Roe written by an anti-abortion activist that makes all of the comparisons in the Alito opinion. And so one of the other ways it's kind of trolling and disdainful is that it's more or less adopting in whole the arguments of a social movement and saying essentially, this is neutrality, right? This is the constitutional, this is fairness, this is constitutional fairness, this is the kind of impartial Supreme Court you're going to get. People who can get pregnant and people of color is one essentially that will tell you exactly what one social movement has been arguing for 50 years and then pass that off as neutrality. And so I think that's really telling too, because of course, if you're thinking about what kind of court we have and how responsive it is to popular movements, including movements led by people of color, if the message is essentially that neutrality is now entirely the arguments made by one side, that's disturbing in terms of how kind of we know then how responsive or not responsive that court will be going forward to claims made by people across a lot of different kinds of areas of constitutional law.
So I would just like to ask, I think that's an excellent point. But in response to that, how much should the work against Dobbs focus on building an equal and opposite social movement? And how do you see that playing in the future in arguments to argue against Dobbs?
Yeah, I mean, I don't, at least historically, everybody who said that the pro-choice movement did not do justice to people of color and to Muslim women, that's, I mean, from what I can tell as a historian, like 1,000,000% correct. There are a lot of moments in the archives, usually around the Hyde Amendment. I think that's usually kind of one of the canaries in the coal mine, where people recognize, wow, people of color are not able to access abortion. And lots of people without income and lots of people with disabilities and young people and rural people aren't able to access abortion. And then you see people in the pro-choice coalition saying, well, we did a focus group and a lot of independent voters don't care about those people. So maybe we shouldn't talk about it. Or, we went to like the kind of moderate Democrat in the Senate and he doesn't really care about those people. So we can't really care about them either. So there's this kind of political pragmatism that's providing kind of justification for marginalizing people of color, ignoring the work of Black feminists. And it's obvious to see that doesn't work very well, because there's then a growing disconnect between the people who are the most affected by these abortion bans and the people who are speaking on their behalf, right? Who are really not speaking on their behalf. And so I think there's been a social movement, but it's been a kind of social movement that's speaking, that isn't really speaking for the people it needs to speak for. And so, yeah, I definitely think that the social movement, there needs to be a very different kind of social movement to respond to Dobbs than the one we've had.
So that change actually just made me think, what does that social movement look like? And I know we're going to be getting later in the day to thinking about what comes next. But one of the things I was struck by what so many of you said, Rafia, thinking about broadening the movement, but also the really important history of who's been leading this movement and the work of women of color and Black feminists all along. I've been thinking a lot recently about the emergence of more white feminists, of wealthy women, and some formerly anti-choice women who now find themselves unable to access the kinds of reproductive care that they had been so accustomed to, thinking anew about whether to join. I mean, this is clearly a Derek Bell entrance convergence moment in that sense. And so if that's what a new social movement looks like, it has the possibility of, again, a very broad, uncomfortable set of bedfellows, I suppose, that are writing on the work of women of color. And I'm curious what you think. Is that the right characterization of what that social movement might look like right now? And what does that mean for us?
But Naomi, that is the old movement. I mean, that is the movement that existed. That's not new, right? Roe v. Wade was a 7-2 opinion. 5 of those 7 justices were Republican appointed. Justice Blackmun, who wrote the opinion in Roe, was put on the court by Richard Nixon. And so I think that one of the ways in which the anti-abortion movement has strategically framed what's happening now is that Republicans have always been anti-abortion, and that's just not true. What it does is it's kind of seductive to people who are naive, who are young, who are like, oh, well, this is what I should believe because this is where Republicans always have been. That's not true. You know, George H.W. Bush's father, Prescott Bush, was the treasurer of Planned Parenthood. George H.W. Bush himself shepherded Title X through Congress, which provides reproductive health care for the poorest of Americans. And Richard Nixon said this is basic health care. So what we see now is a kind of different weaponized movement. But to your point, right, this sort of tent, I think that was the tent. And I think that that was part of the problem, at least in terms of leadership that got us here. If you could have a movement that fails to see when Black women are literally being dragged out of hospitals in shackles and chains in bloodied gowns and say, that's not our issue, we don't see how that's connected, or reproductive rights, total blindness. And that's what we need to address in the next stages going forward. That has to be addressed in what that third Reconstruction looks like, how we don't lose what we gain.
I completely agree. And I, I have to chime in just to say, I mean, when Professor Bell used the term interest convergence, to be clear, that wasn't a good thing. And I think we have to be really, really mindful of that because, sorry, it's so tempting to look at the Brown opinion as a real apex and interest convergence as what made it possible. And of course, when Professor Bell talked about the opinion, it was about there were very real failings to achieve lived equality for Black and Brown families and what a toll that decision took and enforcement of that decision took, in particular on clients, you know, that were many of whom were his own clients and were clients of the Legal Defense Fund, and who suffered a great personal cost for what Professor Bell would view, you know, became largely a figurehead. And, you know, in some ways, Roe functioned in the same way as Mary had indicated, right? Access for a select few, you know, in reality, not addressing the needs to make abortion, you know, affordable, accessible, available to many, many folks who needed it, and yet held up as a, you know, as a beacon of the Roe decision with a, you know, coupled with a real failure to grapple with what it meant. So I think we do have an opportunity, as Michele said, to reimagine what the goal is, right? Roe is not the ceiling, it's the floor. And we have to think much more broadly about what our goals are and be wary of, you know, the kinds of, you know, temporary self-serving goals that got us to decisions like Roe in the first place.
Yeah, and I think also kind of it's almost necessary to have some experimentation at the local level in the short term. But this is going to be the kind of politics of the local for a time. I think what happened in Kansas is representative. I think the messages in Kansas would just like not resonate almost anywhere but Kansas. But it was a good idea to go to the people in Kansas with what mattered to them. And so I think this is a moment. I see this as a moment of kind of instability for the reproductive justice movement. I think, you know, who's going to be running the movement if there is a somebody running the movement, right? I don't think that's clear right now. And so we should learn from the past that listening to marginalized people matters, but also kind of I think it's good to have some of these state by state experiments unfolding because we can learn from them too, right? That there may be kind of 50 movements for reproductive justice instead of kind of one top-down focus grouped refined by polling movement that tells everyone what to say and often ignores people who don't matter to the people in those kinds of spaces.
Let me go to a couple of questions from the audience, and I'll start with a legal one, and then I'll move to one that's a little bit more about thinking about the activism that results. The legal one asks, given the broad powers granted to Congress by the 13th Amendment to get rid of the badges and incidents of slavery, and the connections made by Professor Goodwin and elsewhere by Dorothy Roberts and others, shouldn't advocates and lawmakers be using the 13th Amendment to underpin expansive federal policies to protect various reproductive freedoms and bodily autonomy? Let me start there.
Well, I think that makes sense, and it's a great question. So I want to thank the audience member for that. And what I've discovered in my research is that there has been such a limited um, scope of articulating how the 13th Amendment could work in our daily lives for dismantling the various badges and incidents of slavery that can potentially, in their application, affect us all, not just people whose forebears were Black. And so there's much work to be done in this space. And interestingly enough, there was the debate within the NAACP 50 years ago about how to strategize in dismantling the badges of slavery. Should the 13th Amendment be utilized? Should it be the 14th Amendment? And it was the 14th Amendment that stuck and that, took hold and that, stayed on the wall, and that's been used over time by many different groups. But the 13th Amendment and the record that undergirds it is really robust for matters of reproductive health rights and freedom, and really quite robust for the other badges of slavery that continue to exist. And I think one thing that I'll close with is, just as we see the 14th Amendment's power beyond Black Americans in forging equality and dismantling ways in which people are substantively negatively affected by state discrimination, that we could see the 13th Amendment working in that vein too, right? So one need not see this as, well, this is just about Black people or Black women when we think about the 13th Amendment, but rather see it as a core principle of the American Constitution for liberating us all.
Beautifully said. I don't know if anyone else wants to respond to that. That was a question by Garen Marshall, and let me actually go to a question by Christine Ryan. Thanks to all the panelists. I have a question for Rafia, Zakaria, if there is time. I hear the point about not reducing women's interest in abortion rights to women's sexual freedom alone. Would you mind elaborating on the themes that you feel need to overtake sexual liberation to be more inclusive of women of faith?
Yeah, okay. I think that there are two parts to my response. One is, of course, simply just in terms of the development of legal arguments against Dobbs have to pay some attention to the free exercise portion of those. Can you hear me? Oh. Yeah, okay. To the free exercise portion of the issue, which traditionally has not really been taken very seriously, I would say. So in that sense, I mean, there are one of the first lawsuits. Can you hear me? Hello?
Yep, we can hear you.
Oh, okay. Never mind. So one of the first lawsuits that has already been filed against Dobbs is one filed by a synagogue in Florida, which in which Jewish women are making the argument that their rights, their sort of religiously granted rights against against or for exercising their choice in terminating pregnancies are impinged by the Dobbs decision. So there's the legal portion of it. I think socially it, I mean, I'll give you an example. The New York Times for the past 4 weeks has, I think, run by Michele Goldberg and Nona Aronowitz. And I mean, literally every Sunday, there's an argument about how I love sexual pleasure and how, how this second wave feminists are disappointed in Gen Z. That's not as, is not as into sexual pleasure as second generation feminists were. And I'm only giving the example of those op-eds is because I don't think that those, I mean, in their place, it is fine, but it is, I think, not very productive or pragmatic to connect, you know, a pro-choice political platform with sex positivity as a social issue. I think that if we can manage to keep those separate, we can attract a whole lot more women to the pro-choice camp, you know, even though those women might not agree with second wave feminists on other issues. So in that sense, you know, I mean, I suppose I see it as a pragmatic political choice in terms of constructing a movement. And I think that it is those women who need to have more of a voice on, you know, in the public, despite the fact that, you know, they're not the upper middle class white woman. I don't see any kind of, I don't see any kind of real taking stock of these sort of sins of representation, right? Where the entire abortion issue, the voices are white and upper middle class. I mean, I think that Black women are definitely being included more than they were, but not as much as they should be. And brown women and Muslim women are still almost, you know, they're not present at all in that discussion. So I don't know if that answers the question.
To add one small thing to that point, in Kathryn Kolbert's taped remarks, she goes back and links the very constellation of rights that are at issue in Dobbs to the other 14th Amendment liberties, including contraception, so many of which, and sodomy, are about the right to sex, the right to sex, period, right? And to some extent to the right to sex without consequences, a right that has been enjoyed by men forever. And
right, I think that that's the equal rights portion of the argument, but that doesn't mean that there isn't a free exercise portion of the argument as well. So, I mean, I'm not, you know, what your response is in some ways typical, and I always feel like a necessity almost to sort of, you know, burnish my own sex positive credentials to be even a part of this conversation, and I'm happy to do that. But I do feel that if there's something that has really been left out, it is this issue, is that there are a lot of pro-choice religious feminists, and you know, they might not agree entirely on the on these other issues, which are also important, in which in a perfect world I wish they would agree with as well. But in a world in which we have to create you know, that, as Professor Ziegler pointed out, the kind of social movement, you know, that can supply as much, I suppose, verve and vigor to better Supreme Court justices than the ones that we have right now, then we're going to have to be, you know, perhaps a lot less likely to check boxes in terms of who is allowed into the pro-choice movement.
understood.
Sorry.
No, well done.
If I could, just one point to put out on the table, and then there are the questions. I wonder
Please.
how we can process a culture in which men's pleasure has not only been something that has been a kind of protected within culture, you know, sort of advanced within culture, even protected within law, you know, whether we're talking about this to condoms, no disputes about vasectomies, and just a kind of milieu of boys will be boys, such that even a former president could make jokes leading up to an election, or those jokes being revealed about sex and grabbing people and whatnot, and that be reduced to that's locker room talk. And yet this sense of punishing women when women even think about pleasure associated with sex, right? Like that is just simply not supposed to be, and you bear the cost associated with that pleasure, and you should be ready to bear those costs associated with pleasure. And I think that's also an important thread that's coming out of what Rafia is talking about as well.
Let me actually expand the scope of our conversation slightly by turning to a question from Hetal Dalal. Can we discuss the connections between the liberation struggles of trans people and abortion rights?
Well, I can't help but think about Chase Strangio at the ACLU and being in conversation with Chase and what this period of time, fundamentally represents. And I think about Mary's work in that regard too. The Dobbs decision represents the threat to all of what we see in that arc of freedom in terms of a kind of equality narrative, an autonomy narrative in association with our bodies. And almost immediately after Dobbs, and preceding Dobbs, you see the attacks taking place at the state level against children as they play sports, children and bathrooms, and parents in the state of Texas who would seek to provide love and care to their children in the arc of their ability to have access to the health of health they need. And so I think that it's important to center those discussions too. It's all, I think, a part of the same, this kind of power grab against people's autonomy and privacy with regard to their bodies.
Yeah, I mean, there are a lot of through lines, I think, that the movements, obviously, transphobic movements and the anti-abortion movement have a lot of the same members. There's, I think, historically been a kind of biological essentialism in both movements, right? That your body is what it is and it should dictate what you do and what your fate is. That's very pronounced in both movements' literature. And I think there's also been pretty clearly a message sent by Dobbs that there is now a playbook to get not just the kind of constitutional arguments in Dobbs that can be used against other rights that people either already have or are trying to secure, but also the kind of how it was gone about, right? A kind of chipping away the transformation of the court. I think, I read Brett Kavanaugh's concurrence in Dobbs as a sort of like how-to guide for other right-wing movements that are trying to replicate this, right? I mean, Kavanaugh at various points says, if people don't like a right, and it's only certain kinds of people he's referring to, but if people don't like a right and they demonstrate it by complaining in states and ignoring the right and filing enough amicus briefs, that means that the right is not settled, and that means that the Supreme Court should potentially take it up. And of course, anti-trans activists have heard that message loud and clear. So I think there are lots of areas of overlap that I see, starting with the fact that it's often, but not always, the same people in both movements.
Just two things that come to mind listening to Mary. And one is, again, I feel compelled to repeat the crabbed formalism, right? The doctrinal arguments and the doctrinal theories here also can look very similar and also are not new. They come from a very old playbook. And so I talked earlier about, the notion that separate but equal is, if you think that implies that one group is inferior, that's sort of, that's on you. And it reminded me of arguments that were advanced by opponents of marriage equality that said, well, these bans on marriage for same-sex couples are not, don't actually discriminate against LGBT people, because anybody can marry a person of a different sex, right? So if you're gay, you can marry a person of a different sex. If you're straight, you can marry a person of a different sex. If you think that's discrimination, right, that's your own choice. And we see a through line too with the anti-trans legislation and the arguments advanced it, which is to say, these bans on gender affirming care apply to everyone, regardless of sex. Of course, again, everyone knows what do they actually do. They only impact people who are transgender, but as a formal matter, there's a real appeal to this idea that on its face, these laws apply to everyone, which of course was precisely the reasoning that won Mezey and Plessy. And of course, with the Dobbs opinion, anti-trans advocates are seeing real encouragement that those arguments are once again welcome and will be accepted, despite what we all know to be true.
Thank you for those fulsome responses. And I want to go to a question from Minnie Tang in the Q&A. It's directed to you primarily, Ria, but I'd love others to jump in. She says, when you mention progress will always be responded with more suppression. This reminds me of Rebecca Traister's book, Good and Mad, who described the process of change as slow, hard, and often circular. Would you mind sharing more on how we should respond and take back these rights that have been so fought so hard for? And really, this is telescoping us to the thinking about the future. I know we're going to get there at the end of the day, but I wanted to allow all or any of you to think about that now, because we'll have others talking about it and we would love your insights.
First of all, this is a terrific question. I often channel Rebecca Traister's rage, and since it was directed at me, I feel I should respond first, although frankly, I don't have the answers. It compels me really, I think, in fact, to just point out one more pessimistic fact, which is that another aspect of the long game here, of course, was the intentional voter suppression and the acceptance and regularization of voter suppression. So it was not only convincing Americans or Republicans to prioritize justices who were counter-majoritarian, but also, in fact, to chip away at voting rights, so that at the very moment that the court could claim to be returning this political question to the states and people could vote with their feet, at that very moment, of course, the court had already ensured through Shelby County and other decisions that many of those state legislatures were represent deeply gerrymandered districts that systemically disenfranchise Black people and other voters of color, that those legislators were elected via laws that intentionally made it difficult for Black people and other people of color to vote. And so at the very moment this right was returned to the states, of course, the ability to vote and the ability to, in fact, express one's political will at the state and local level was so severely curtailed that we could have a situation that we have now, where we see the state map and the state level restrictions on abortion are so far removed from what people who actually live in those places want, just by the numbers. And that's not an accident, right? That was also by design. And I say that only to say that, well, of course, we all have to vote, and it's encouraging to see what happened in Kansas. Voting alone won't be enough. We have to think about how we can really reshape the court so that voting can again have what was once its incredible promise as the right preservative of all rights. At this moment, that too has been stolen, and we can't think about one without correcting the other.
Thank you. I want to invite anyone else to jump in if you would like. Mary.
I guess, I think channeling rage is important too, in part. I just think when people ask me this sort of question from the viewpoint, and I share this feeling of sort of at moments where you feel there's not a lot that can be done, or that progress is circular. I think of how conservatives responded to Roe, right? It took them 50 years. And so I think that there's a certain, even though the impulse to be depressed and frustrated is obviously necessary, I think that this is going to have to be, and even for them, I think often if you're moving against what voters want, the arc of justice, it takes a long time to get anywhere too at times. So I think a willingness to ignore those impulses at times, even knowing that it will not be easy, is really important. Because, I think in effect, we learned from Dobbs that will be true of conservatives, right? They're in it for the long haul too. So I think it's important, if we're thinking of what kind of movement we want, to be, to be cognizant of that, and to know that any kind of progress at all, even if it's not lasting, or even if it comes with some steps backward, will have to require that kind of long-term commitment.
So I want to chime in here and think about the presentation that Krystal gave, and also channel a long arc of legacy of individuals who fought against what seemed to be just unbeatable odds, right? That's colonialism, that's American slavery. In more modern terms, it's those advertisements that were put in the New York Times when there weren't any Black women in the Senate and barely any in Congress, and the aftermath of the Thomas hearings being one that was absolutely robust, that produced a Black woman in the Senate, Carol Moseley Braun, et cetera. And so when we think about these arcs, one part of it is true. I think about the work of Reva Siegel and the sort of transformation of inequality over time, right? So the advancement against something that is horrid being transmuted into something else, slavery being transmuted into separate but equal. And I think that says a lot about just power, how people in power will seek to do runarounds whenever they can. But I can't help but pay homage and respect to all of those who fought mightily and have against systems of inequality and oppression that have opened the doors for the liberation of so many more that they could not have imagined. I can't help but think about, as I say sometimes, what must a mother have said to her child the night before the slave auction in a nation that denied that child any kind of humanity, that said that that child could only be property, and that child being taken away. But there's something that was voiced by that mom the night before the slave auction that would keep that child whole for another generation or two, leading us to where we are now. I really do think that there will be a third Reconstruction, but my concern is how we lose it. And I think that we lose it much in the same way in which we tolerated a Jesse Helms in our Congress, right? I mean, you think about it, that's just old Uncle Jesse, a person who was self-affirmed as misogynist, racist, homophobic, etc. There should not be tolerance for that in our House of Government. But that wasn't just, sort of Republicans tolerating him. That was Democrats tolerating that. And so I wonder about our third Reconstruction actually getting there. What will we be able to hold on to as our principles and values against intolerance and not slip into, well, that's just old Uncle fill in the blank being that way and holding the keys to power?
Really quickly, if I can just add, identifying as a radical Black feminist who also is very invested in the electoral process of things feels like a contradiction so many times. But I think what it does for me is it forces me to have to think through values and how they land for people while they're either voting or just whatever opinions or takes that they may have on things. And one thing that I think is coming out of all of this for me is there's so many polling that happened when the leak happened, and also when the decision actually came down. And people that generally may play a little bit more of a middle ground are moving towards not playing so much of a middle ground. But also one thing that came out of it that I think needs to really inform how we go about doing work on the right side is people didn't take the threat seriously when it came to the decisions that Supreme Court were looking to make. And they've been telling us for at least 50 years what they were going to do. And people just didn't believe it until it actually happened. So hopefully all of the other issues that are being threatened right now and that are being front and center, that are clearly being communicated as things that they want to get rid of, are taken a little bit more seriously and also reflected by way of elections and polling and things like that, so that campaigns and people that are interested see these things and take them seriously. Again, most candidates, I think people are typically surprised when they hear this, but most candidates already do identify as pro-choice, but being pro-choice the same way that Roe v. Wade is not enough, it's not going to take us where we need to be. People need to be really going as hard as possible on these issues, whether they're stakeholders, elected officials, funders, and things like that. And that's really the only leg up I think that the other end of the spectrum has. They're not smarter than our side. They're not more brilliant. They're not coming up with anything new or fresh or innovative or creative. They're literally just have a different hold on the electoral process and a different long-term strategy that they also took in some ways from our strategies within the civil rights and gender justice movements as well. So I think like the combination of acknowledging the harms and the things that are scary and the things that we're fearful of is important and necessary. It's not something I think we should force ourselves to push down in any ways. But at the same time, I think there's just the veil that's being lifted right now. And it's being reflected in the polls and in the exit, surveys and things like that that are happening with organizations like the Kaiser Family Foundation. I think it's up to those that do electoral work or do this kind of work in general to make connections. And again, get out of our silos, get out of our normal talking points and really inform people. I'll just close in saying I was very frustrated myself with the very flat vote, response to all these things. when we know it's not just voting that got us here. And I think we need to be clear about what's actually on the ballot, what are the actual opportunities, how they may land in communities, what works for different communities, and how voting in multiple different venues of things and avenues will, I think, get us a little bit closer to where we're trying to be.
Krystal, that is a beautiful and powerful place to end. Thank you for taking us there. And I want to just spend 1 minute thanking our panelists today, Michele Goodwin, Krystal Leaphart, Ria Tabacco Mar, Zakaria, Mary Ziegler, Kathryn Kolbert on video, for really giving us this sense of where our history has been, where our debts are, who we owe the triumphs to, and where we need to draw inspiration in moving forward. And I feel like beginning with Cori Bush's righteous indignation, feeling good and mad, but feeling incredible gratitude for the intelligence, the passion, the tireless work and energy that all of you have given to this movement and to what lies ahead. I am so grateful. I'm grateful for you being here with us. And here's to the long game. I want to remind everyone their second panel will begin in an hour at 12:30. And I hope some of our panelists can join us for those sessions as well. Thank you again for being here.
Thank you all so much.
Thanks for having us.